Hey, hello, welcome to an exciting episode of Contract Law, Standard Terms and Conditions. I'm going to take you through it. Come with me. So I bet like maybe 1% or 0% of you has ever read the general terms when they were handed or offered to them. They're very boring usually, the small print, the small letters that you never read. But how can they be such a topic then? What is their importance? Well, first of all, it's very important because they are Chapter 5, Book 6 of the Dutch Civil Code. So there are special rules for general terms. They have some kind of importance and we are going to figure out what it is. What are standard terms? I think we all know it as the small print. We also all recognize it maybe once you have to click I agree before you can order something online or before you can make a reservation. Well, there at that moment where you click I agree is actually your chance to see the general terms and to agree with it or not. But we just all click I agree and hope for the best. And that's a good thing, I can tell you. General terms. General terms are a firewall for a company. So they serve companies, businesses. They are not for people, consumers like you and me. We do not make standard terms. We are only dealing with the one-sided general terms of companies. They are meant to be repetitive, these general terms. They save time and money because they give rules for general things like payment conditions. Where can you complain? And the best feature for me when I want to protect a business is that I exclude liability to the max with it. I do anything to make the liability go down to like zero if I can. So it's a big protective tool for companies, minimizing liability, maximizing the profit, and that is the aim that we have for your business. As you can see in the picture, if you already watched Contract Law Part 2, you might recognize the big man, Article 674 from the Contract Law, and a very tiny, small, little kid, 675, that is a force majeure. In our law book, those two articles are opposite from each other. If you have a contract, you have to perform. If you fail to perform, you are liable for the damages. That is 674, a very strong article. The only time that your liability will be excluded from the law is with 675 when there's a force majeure. That's an act of God, like a tsunami, something that's totally out of your hands, a war, and the whole country closes down. So there's a very small chance that you can apply 675 to your case. That's why 674 is a massive article. For companies, I already said, it's really important the way you set up your contracts because contracts hold obligations. Obligations are one side of the medal, one side of the coin. The other side is liability. Liability is a risk. Liability will cost you money. And to protect yourself against that liability, that strong Article 674, we make general terms. And there you see, we also created a fighter against 674. So you exclude your liability. You get a lot of liability in contract law, and with your standard terms or general terms and conditions, you can call it anyway, it's all the same. With these general terms, you lower your liability and you protect your company. So it's a very handy tool. I have a little clip from YouTube and that's a lawyer that really perfectly explains it. So if you can watch it, you know everything. Here it is a slide with text because we don't have a book, and sometimes I put everything for you on the slides in case you want to read everything. Here is a very brief overview from the law. What are the standard terms? Well, they are terms to protect a company. They're used over and over again, and the a very important feature is they are part of a contract. So they're part of a contract. But how do you make them part of a contract? You have to give people an opportunity to read them or know about them because people have to accept them. Do you recognize again the formation of the contract? The same goes for the part where you have the standard terms. You have to offer them and the other party has to accept them. And that is also exactly why you always have to click I agree. With I agree, you accept the terms that are offered. Whether you read it or not, you had an opportunity to read them. That is enough. Can you write anything you want in the general terms? Yes, you can. Really, anything. I exclude all liability. It doesn't matter if I did it on purpose or if I sent you the wrong articles. I just am never liable. You could put that in your general terms. It's not a criminal fact or something. But it would be very unreasonable, very unfair. And therefore, the law also makes like an arrangement to create balance, because companies one-sided put these general terms on you. You like have to accept them or you cannot participate in any sales or reservation or anything. So the law says if your term is unreasonably burdensome, if it's really very unfair, that means then you cannot apply that term. And also the lawyer made already, the legislator made a blacklist and a grey list, and there are situations and rules for things that are not accepted. For example, if you order an item online, you are entitled to get that item. A company might say in its general terms, we reserve the rights to send you another article that is maybe similar or less similar, but that's not allowed. Another thing is when there is a liability really given to you in the law, you cannot just exclude that. You also cannot exclude your liability for things that you do on purpose. That would be very weird, you know, if you would on purpose not deliver, you would on purpose take things from your hotel guests. It would be very strange if you could like exclude your liability for that. So that is not possible. So there are boundaries. The boundaries are given in the law. You can write everything you want in your terms, but they could be unreasonable and then you cannot use them. So that is how it goes with the general terms. I have put some articles for general terms in red. You see the features of general terms. Please do not memorize it. It's just to inform you and show you like, yes, this is exactly how it is in the law. What is a little bit fun for you is to go over the uniform conditions for the hospitality, for hotel and catering industry. Because there are also things in that is not liable, is never liable. Catering is never liable for any damage whatsoever suffered by the customer. Unless it says the damage is caused intentionally or grossly at fault. Grossly at fault is close to intentionally. It's that you took a really big risk and something went very wrong. So maybe that's okay, maybe that's not okay. So think about it. Is it unreasonable or not? There are no black and white rules for this. This is also really, there is always a gray area. What is allowed still and what is not allowed. And of course, companies will exclude anything and try to push the boundaries always to their advantage. This is an overview of standard terms in hospitality. Everybody excludes their liability 100% and then waits for somebody to object. And that's basically what all the companies do. Because you can put anything in your standard terms and maybe it's unreasonable, but if nobody tells the company, listen, I don't accept this term because it's unreasonable, they just use it, and they also use it against people. And that's actually for a company a very nice thing, because if you make unreasonable terms but 90% of your customers accept them, that gives you a good benefit, you know. That also minimizes your liability even more than even the law would allow, but still you have a benefit from it. If you for example if people don't pay and you give them kind of a fine, there are really companies that do that, and 90% of your customers just pay that fine because they didn't pay in time and they think it's all allowed, then you have that money. And that's not a criminal fact or something. You can really do that. That's a part of the freedom in contracting. So then it's often very unfair. Always look into it in case you're in trouble. This is a recap with all the features of standard terms, so you can go over it and think, okay, I got it. Standard terms basically will feature in your IRAC. The classic situation is that we have two parties. For example, party A performs 100%, party B performs 50%. Party A says, listen party B, you performed only 50%, you owe me the other 50% based on Article 674. And then party B says, oh, party A, that can be, but I made general terms, and in my general terms, I excluded liability for that 50%. What do you have to do then in your IRAC? Well, first of all, you check standard terms. Were they offered and were they accepted? So did party B offer them to party A? Did party A actually accept the terms? You can accept them by for example, if you go into a supermarket and it says you have an obligation to take a shopping cart, that is a general term. If you go in, you accept the term. If you click I agree, you accept the terms. So there has to be something, an action or a real click or signature. There has to be something that indicates an acceptance. Offer acceptance, check it. Next check you perform with standard terms is, do you think a term is unreasonable or not? And you have all the freedom in the world to choose whether or not you think it's unreasonable or not. That has a consequence, of course, for the rest of your IRAC, so I will check whether your IRAC is in order. It's all about the analysis at your test, not about giving the right answer, because that would be very hard, because especially with a topic like general terms, it's very hard to predict if something will be accepted as unreasonable or not. So you have all the freedom. Just perform the two checks. Offer acceptance. Is it unreasonable? That's really what I would like to see. And here is an overview of everything I told you, but then in writing. And that's it. One tip before you go. If you go out and you want to hang your coat somewhere and there's a person there that accepts your coat and gives you a number, this company is liable in case they lose your coat. Although you always see a sign, management is not liable for the loss of your goods. They are liable. This is a general term that is unreasonably burdensome, and 6237 sub F is on the blacklist and says you cannot exclude this liability. If you take a code and you have to pay for it, or you don't pay for it, and you give people a number, so you promise to keep the code safe, you have to keep it safe. You can never ever exclude that. And that's it for today. Thanks.